I don't believe it. Trulieve sues the state over a medical cannabis license. Georgia got sued by Trulieve on December 22nd, 2020, one of the largest cannabis companies in the United States, multi-billion-dollar market cap, submitted a bid protest to the Georgia Department of Administrative Services. In the lawsuit, the company seeks to overturn requirements implemented by the Cannabis Commission of Georgia, the Commission, to the request for proposals for Class 1 medical licenses, the RFP. There are currently two types of Georgia medical cultivation licenses. Class 1 production license, and if you want more on this, click like, click subscribe, and check out our Georgia medical cannabis cultivation video. Now the Class 1 allows for the license holder to produce low THC oil and has 100,000 square foot of cultivation space in its canopy. The Commission shall issue only 2 of these Class 1 production licenses. However, the Commission also has the Class 2 production license, which is essentially 50% of the size of the Class 1. They can produce low THC oil, but they're limited to only 50,000 square feet of cultivation space. The Commission shall issue 4 of those Class 2 licenses. Let's get back to the Trulieve lawsuit. According to Trulieve, the plaintiff, the Commission exceeded its authority designated by the General Assembly and therefore improperly tried to legislate the terms of Georgia's medical cannabis law, the HOPE Act. Trulieve alleged the Commission sought to modify the requirements of the RFP by utilizing criteria that do not exist in the statute and changing the definition of a material term that is contrary to the statutory definition. Through these actions, the Commission has exceeded its statutory authority, the impact of which is to significantly limit competition for this RFP. As if the $1.25 million bond you had to post wasn't limitation enough. Anyway, through this lawsuit, Trulieve requested to eliminate the requirements that an entity must have operated in Georgia for at least 5 years to constitute a Georgia business and comply with the statute that requires minority business participation as either owners or suppliers, and follow the broader definition of products as stated in the statute, rather than the more limited definition adopted by the Commission in the RFP. The real ironic thing is that Trulieve exploited the Florida residency requirements to just lock down the entire Florida market. They're 1 and 2, and they're 50% of the Florida sales. That's why they're a multi-billion-dollar company. However, now, when it doesn't suit them, they are arguing against these types of requirements in Georgia. It appears Trulieve's real intention probably had to do with delay, because the RFP application submission window was set to close days after the bid protest was filed. Furthermore, Trulieve also requested that the RFP did not close until after a final decision regarding its protest. Maybe they needed more time to get their RFP in order so that they could submit it. The deadline for the RFP for the Georgia medical license would have expired on December 28th, 2020. Now let's do some background on the Georgia medical license. Georgia's HOPE Act was enacted in 2019. You can read about it in Georgia's medical license in our article at cannabisindustrylawyer.com. Just go there and search for Georgia or search for marijuana map and then click on the state of Georgia. Real easy to find. Following the enactment of the HOPE Act, the Commission issued the competitive application requirement requests and proposals for Class 1 and Class 2 medical marijuana licenses on November 23rd, 2020, only giving applicants 4, maybe 4.5 weeks to get their entire application in order. The Georgia Code and Georgia's HOPE Act outline many aspects of the application that the Commission issued. Among these aspects was that the Georgia legislature granted to the Commission many powers, responsibilities, and duties required to implement the law. In this sense, as signaled by Trulieve, the Commission has the authority to 1. Establish procedures for granting medical licenses. 2. Establish applications and forms necessary to carry out the provisions of that part of the statute. And 3. Establish criteria for applicants and licensees necessary to ensure adequate supply in the market. Further, the Commission stated in the RFP that the statutory framework as set forth in the HOPE Act provides for considerable authority to conduct the competitive application process. It also states that if the terms, conditions, instructions, processes, procedures, actions, or requirements in the RFP are inconsistent or conflict with the Georgia Procedural Manual, such derivations are permitted. Trulieve disagrees with this by alleging that the RFP does not and cannot state that any deviations from the HOPE Act or the codified laws are permitted. And although the RFP mostly tracks and incorporates the relevant statutes and requirements from the regulations, the RFP contains requirements that differ from the statutes. At least that's what Trulieve alleged. Trulieve points out at least 3 of these deviations. Alleged deviations. First, they allege that the Commission stated that the applicant must be a Georgia corporation or entity without defining what a Georgia corporation is. Trulieve footnoted to the famous case out of Maine that threw out the residency requirements for an out-of-state operator that wanted to participate in the Maine cannabis industry. This might be another one of those types of lawsuits, and many more of them may be coming, especially after federal legalization, for reasons which we will cover on this YouTube channel. So give us a like, give us a thumbs up, and then you'll see why the 14th Amendment really doesn't allow these types of residency requirements. Next, the RFP indicates the following types of evidence so that an applicant can substantiate that it is a Georgian-owned company. They have to have ownership and control of more than 50% of Georgia legal residents who have been legally residing in Georgia for not less than 1 year immediately preceding the date that the application was submitted, or annual registration and business tax returns that document the corporation or entity has been actively registered to do business in the state of Georgia for not less than 5 years immediately preceding the date the application was submitted. As an aside, considering that this law didn't arise until 2019, that they would then say that you had to be in operation since, 2014 or 2015, doing what? They didn't have any medical cannabis. The Georgia statute also requires a demonstration of significant involvement in the business by one or more minority business enterprises as defined under a certain section of the code, either as co-owners of the business or as significant suppliers of goods and services of the business. The RFP eliminates the option, and then instead the RFP gets rid of that association and requires them to be an owner and perhaps also a supplier. Lastly, Trulieve alleges that the RFP FAQ's documentation, in there, the Commission modified and restricted the statutory definition of product away from the Georgia's legislature's text. The HOPE Act defined product as an expansive matter to mean, in relevant part, low THC oil delivered through an oil or tincture. However, the Commission's FAQ stated that Georgia law does not allow production or manufacture of production for cannabis tinctures, topicals, rapid onset sublinguals, edibles, inhalables, etc. These products are purportedly, under the FAQ, prohibited for manufacture and sale in Georgia. In all respects, Trulieve alleges that the Commission exceeded its authority by issuing the RFP contrary to the terms of the HOPE Act, and as such, the Commission should be stopped from legislating inappropriately. According to Trulieve, doing so would ensure the Commission acts within its powers rather than attempting to legislate and create a level playing field for all interested applicants. If you believe that. I don't think a level playing field is $1.25 million or a 100,000 square foot cultivation and processing facility. I also disagree with the low THC oil. I disagree that there's no flower. I disagree that they're still arresting people in Georgia. I disagree that Atlanta doesn't have legal cannabis. The people of Georgia deserve better. They deserve safe access to the plant, and they don't deserve this type of grandstanding by one of the largest players in the cannabis industry to occupy the field of Georgia so that when the people of Atlanta can actually buy cannabis, they're going to be buying Trulieve's product, as opposed to buying product made in Georgia. Hope to see you next Wednesday or Sunday on Cannabis Legalization News.